Welcome, everyone. I'm David Meyer. I'm the Dean of Tulane Law School. And on behalf of the law school and the Eason Weinman Center for International and Comparative Law, it's really my great privilege and pleasure to welcome you to this very special event this evening. This event is a virtual conversation about the latest work of our renowned colleague, Vernon Palmer. His latest book, The Lost Translators of 1808 and the Birth of the Civil Law in Louisiana. One of the great joys of being at Tulane is to be exposed and immersed in this rich history of this place. And that, of course, includes the rich history of Tulane and the nearly 175-year-old history of Tulane Law School, but of course also the unique heritage of the civil law in Louisiana. Perhaps no one knows more about that history of the civil law in Louisiana than the individual we honor tonight, Vernon Palmer. Throughout his career, Professor Palmer has authored more than 40 books and articles, many of which specifically explore the history of Louisiana law. Professor Palmer's books, Louisiana, Microcosm of a Mixed Jurisdiction, and the Louisiana Civilian Experience both highlight the unique mixed nature of Louisiana's civil law tradition and how that tradition has shaped Louisiana's own history and culture. Through the Codes Darkly, another of Professor Palmer's works, reckons with Louisiana's slave law and the history of the Code Noir. Professor Palmer's articles on equity in Louisiana law have illuminated the historical underpinnings for the state system of contract law and also how it has helped to shape the future of Louisiana's legal system. Tonight, we honor Professor Palmer's work, his latest work, focusing on the translators of the foundational document of Louisiana's civil law system. In 1808, the Louisiana legislature appointed two men to translate the digest of the laws enforced in the territory of Orleans, or what was simply called the Code, from the original French into English. These translators were never identified. Their identities, personalities, and credentials kept secret until now. Through painstaking research, Professor Palmer has uncovered the identity of the translators and shared with all of us their life stories. With this information, all Louisiana lawyers and historical enthusiasts can now read the 1808 Digest, which you have been seeing through the slides displayed now, and with much more depth and much more understanding of the people who helped to create Louisiana law. Joining us tonight, we're really privileged to welcome three distinguished scholars internationally to share perspectives about Professor Palmer's work and more broadly about translations in the civil law. First, we're honored to welcome Augustine Parise, who is a professor on the Faculty of Law at the University of Maastricht. He is an expert on comparative law and private law, an associate member of the International Academy of Comparative Law, and director of scientific studies of the International Association of Legal Science. He is going to share with us his own work entitled Sundry Expenses with a Distinct Value, Translations and the Codification of Private Law in Antebellum, Louisiana. Thank you so much, Professor Parise.
Thank you very much, Dean Meyer, for the kind introduction. Good afternoon, or I should say good evening from the Netherlands. It is a pleasure to join you, all of you, today in this festive occasion. We celebrate the golden jubilee of Vernon as an educator and his recent addition to Louisiana legal history. I thank the organizers for the invitation. It is very special to be back in Louisiana, a very fruitful place to undertake comparative legal historical research, and a fruitful place to nurture friendship. I thank Georgia Chadwick for sending me a copy of Vernon's book with his signature and a nice message. Georgia offers a bridge between Louisiana and the civil law world, always. It is a privilege to discuss and reflect today on a work that takes us in a journey of discovery. A mystery is solved with Vernon's book. We're invited to assess the place of legal translation and translators in the shaping of the law in Louisiana and beyond. 19th century Louisiana may be considered a civil law island, partially surrounded by a sea of common law, a status that had to be safeguarded to survive. Resources had to be assigned and efforts had to be made to protect that status. And Vernon reminds us that translations played a key role. The title of my talk today finds inspiration in the Louisiana Act of March 31st, 1808. There we encounter the names of the translators, Henry Nugent and Auguste de Vezac. That act is entitled An Act Providing for the Payment of Sundry Expenses Incurred in Revising and Copying the Civil Code. The legislature believed that the translation fitted within the description of a sundry expense with a C in the original. Sundry can be replaced by miscellaneous or general, clearly not something that merited special attention, not being something of a specific or determined value. Vernon's book confirms that translations have a specific, a distinct value in Louisiana and beyond. Translations, in this case of the digest, had a distinct value in helping preserve the civil law in Louisiana. Further, they helped develop a specific identity. Vernon shows that systems can be challenged by a lack of language uniformity. He also shows us that translators offer tools to bridge divides, tools to operate in a specific system. Translators undertake creation, as pointed by Vernon. My short presentation today invites to look at Vernon's book from three main angles. First, the need for translations in antebellum Louisiana. Second, the place of the translation of the digest within the context of other Louisiana translations. Finally, the role of translations as tools for codification. My short expose aims to highlight the distinct value that translations had and have in the codification of private law. Let us look at Vernon's book from the first angle, the need for translations in Louisiana. Vernon tells us in his book, and I quote, that any lawyer who knew English only and nothing of French or Spanish was disadvantaged as an advocate, end quote. I fully agree, and the legal and social history of Louisiana confirms that statement. For example, Spanish laws were not abrogated with the enactment of the digest. Raphael Rabelais, who is today in the room, alerted us 40 years ago already that Louisiana courts relied on Spanish and French sources during the period of 1809 to 1828. Those diverse sources called for translations, if willing to deal with otherness. Back to Vernon's words, and I quote, New Orleans had a built-in need for translators and translating services, end quote. Again, I agree. Court decisions bring light to the need for translations. For example, the Spanish partidas were cited before courts in antebellum Louisiana. The 1821 decision in Schoof versus Morgan offers a prime example of the linguistic collage that took place at court. It reads in part, and I will quote verbatim. La partida supposes a sale and inquires only a quién corresponde el daño en las cosas que se suelen contar o pesar o medir después que fuesen vendidas. The law declares, el daño en la cosa después que es vendida es del comprador. Pero ¿qué casos y cuándo no sería así? It is not the case. What is the antecedent of a C? End quote. We can all agree that the excerpt that I just read encapsulates the urgent need for translators and their work in Louisiana. Let us now look at Vernon's book from a second angle, the place of the translation of the digest within the Louisiana translation environment. Translations were made of legal texts in Louisiana before, around, and after the time the digest was translated. Working knowledge of not only French, but also Spanish was more than a convenient tool, it was a requirement. Communication was taking place in many directions. Courts appointed interpreters to move from Spanish to English to French. Translations were needed from French into English, from Spanish into English, and also from French into Spanish and vice versa. There was a need to understand the law. French and Spanish authorities were cited often in court. We can mention, for example, the 1769 Spanish ordinances by O'Reilly, available in Spanish, English, and French. Later, we can also point to the 1818 and 1820 translation of the Spanish partidas, led by Morito and Carleton. Spanish law found a means for survival in Louisiana through translations. There was a network, a circle of translators in Louisiana. And this takes me to a statement in Vernon's book. He refers to, and I quote, a veritable who is who of the bar, end quote. And Vernon places those two translators within the group. This reminds me of the late Louis de la Verne, the guardian of the digest. Louis, many of you will agree, would be very happy in this room today. Louis used to speak about a circle of a network of recurring actors in the foundational period of Louisiana law. For example, 5 jurists can be associated to the translation of the Spanish partidas. Morito and Carleton, who I just mentioned, but also Livingston, D'Herbigny, and Massero. I found 12 Louisiana cases where the partidas are cited in the period 1818-1819. In all but one of those cases, at least one of the 5 actors is involved. The 5 actors were therefore among the most authoritative when talking about the partidas in Louisiana at court. The lost translators, as mentioned by Vernon, were part of that circle, of that who is who. A final word to further contextualize the work of the lost translators. Their work was followed by other translations that were very much needed. For example, we can point to Gustavo Schmidt, and from beyond Louisiana to Joseph White and John Rockwell. But there is still a need for translations in Louisiana today. And our friend Olivier Morito, who is in the room today, is one of our speakers, is currently leading the French and Spanish translations of the code. Let us now look at Vernon's book from a third and final angle. Let us look at translations as tools for codification. Codification endeavors many times build on previous experiences that proved to be successful. Not all codifiers mastered foreign languages. Translations, therefore, were tools of trade that played a fundamental role in the development of legislation. The work of the lost translators shows how those tools of trade were used during the 19th century codification. Codification endeavors excel in illustrating the transfer of legal ideas across jurisdictions and even across continents, crossing oceans. That transfer required the elaboration of translations to fully achieve its potential. Vernon says in his book, and I quote, "I wish to draw attention to the pedagogic aims of the English translation," end quote. Practitioners, courts, and translators welcomed literature that would succeed in making the law accessible to them. Analytical works were therefore well received, providing a universal approach to the different areas of the law. This could help explain once more in Vernon's words, and I quote, "why the first Louisiana codes were equipped with exceptional features not otherwise found on the continent, such as bilingual indexes to the contents alphabetically arranged in French and English," end quote. Translations were tools and still are tools that help disseminate legal ideas and foster the circulation of legal models. A few words to conclude. My short presentation today invited us to look at Vernon's book from three main angles. First, the need for translations. Second, the place of the translations. And finally, the role of translations. Translations in Louisiana had a distinct value. We cannot consider them a sundry expense. It would not be fair, but above all, it would not depict reality. Louisiana welcomed translations for more than 200 years. There has always been, and should always be, a connection between Louisiana and other civil law jurisdictions. Louisiana must build bridges with other civil law territories to keep developing its own civil law heritage. It must benefit from developments in other jurisdictions, and it must share its own developments with others. Vernon reminded us of this reality when unveiling the life and work of the lost translators. The translation of the digest provided an early example of that bridge-building activity. The need for translations of legal materials in Louisiana can be indeed explained by looking at legal history and comparative law. I therefore can only celebrate that Vernon is an expert in both fields. And above all, I also celebrate that he has been sharing his findings with us and with his students already for 50 years. Thank you very much.
Thank you so much, Professor Parise, for that commentary and that tribute. And next, it's my great honor to introduce Professor Olivier Morito, who will be sharing with us his perspective on natural law as a third space in civil code translation. Professor Morito is the Russell B. Long Eminent Scholar Chair at LSU Law Center. He's an Associate Vice Chancellor at the Law Center and also Director of the Center of Civil Law. Like Professor Palmer, Professor Morito's long list of scholarly contributions is too long to pay tribute to here, but he is a member of the International Academy of Comparative Law, of the American Law Institute, the World Society of Mixed Jurisdiction Jurists, and the European Society of Comparative Law. Thank you so much for joining us, Professor Morito.
Thank you. Dean Mayer, Dean Richardson, dear Vernon. It is for me an immense honor as a French professor lost in Louisiana and at times lost in translation to participate in the launching of the Lost Translators of 1808 and the birth of the civil law in Louisiana. Vernon Palmer tells the story of those who translated the old Louisiana Code from French into English. I could tell my story of translating the current Louisiana Code from English back to French. Most probably, Vernon's translators were doing the right thing, and I'm going the wrong way, and in that sense, I may be lost. The translators of the Digest of 1808 went the good way because, as Vernon has it, they contributed to the birth, or as others may say, the survival of the civil law in Louisiana. The fact that 200 years later, I could translate from the English back to the French indicates that the work of the lost translators was not a lost cause. In the past few years, our Louisiana Civil Code has received a French and a German translation. It is currently being translated into Spanish. Mariano Vitetta will discuss his translation work next week at the Law Library of Louisiana CLE, also on Zoom. Whether our Civil Code translations go one way or the other, they prove the vitality of the civil law in our state. Translation studies point to the existence of some uncharted space that exists between two languages, a sort of in-between or an entrelangue. The French jurilinguist Anne Wagner calls it a third space. This term echoes the tertium comparationis that lies at the core of comparative legal studies. This third space refers to the essence of concepts and principles articulated in our codes, which exist outside national languages. Walter Benjamin called this pure language. We civilians identify it with the spirit of the law. Take the old Article 2279, now 2276, of the French Civil Code, en fait de meubles, possession vos titres. These 7 words express French custom as applied by the Châtelet de Paris long before the drafting of the Napoleonic Code, wherever whoever possesses movable property is deemed to be the owner. It makes exception to the Roman law rule, nemo dat quod non habet, and is phrased in a French that resembles a Latin maxim. It is hard and clear like pure diamond. How can we translate these words into English, keeping it transparent and pure? Regarding movables, or with respect to movables, possession conveys the title. There is no sense of conveyance in the French. Vaut refers to essence and should translate by is or is equivalent to title. But does title suffice? Should we say ownership? Let me give a few samples of translations of this article in the French Code. The English translation of 1811 says, in matter of movables, possession is title. Also 7 words, and it mirrors the French. The translation of 1824 by a barrister of the Inner Temple says, in the case of movables, possession is equivalent to a title. Introduction of an article. Not sure this is good. Henry Cachard in 1930s writes, possession is equivalent to a title with respect to personal property. We move from 7 to 11 words in common law terminology. Probably a no. The compiled edition of the Civil Code of Louisiana 1942 says, with respect to movables, possession is equivalent to title. And finally, I'll give you the Louisiana translation of 2013 or the Michel Séjean of 2020. As far as movables are concerned, possession equals title, 9 words. Well, I salute the first translation, the 1811 work of Brian Barrett of Gray's Inn, in matter of movables, possession is title, 7 words, crystal clear, mirroring the French. Walter Benjamin, not Judah Benjamin, though he was no doubt familiar with the third space, wrote in 1923 a beautiful and cryptic essay titled The Task of the Translator. In his view, the task of the translator is not that of a communicator, but of a craftsman contributing towards the achievement of the text by some sort of alchemy. The translator's task aims at expressing the most intimate connection between languages to identify a core that resists translation. He discusses translatability and identifies a vital link between the original and the translated work with pure language connecting them. Benjamin accepts that the transfer can never be total, while admitting that a good translation contributes to the completion of the original text, sometimes making the pure language more present than in the original. Walter Benjamin believed that we get best results when translating religious scripture. After all, Pierre Legendre called the Corpus Juris Civilis l'autre Bible de l'Occident, the other Bible of the Western world, and this may apply to our civil code. Robert Pascal, citing Ulpian, say that we were priests of right order. This may sound esoteric and too religious to some, but law connects with our deep and higher beliefs. Alain Levasseur, who likes clarity, tells us that though civil codes are in plain language, they need to be deciphered. They must be interpreted. And there is a rich literature visiting the intimate relationship of translation and interpretation in the context of the law. François Host has written beautiful pages on the topic. The spirit of the law is encoded in the words, and the text, if the text is well written, it blows through the words, it makes them glance. Achieving this with translation is an art. The better the text, the higher the challenge. I come back now to the challenge of the early translators. They were the first ever to translate a civil code into English. Though Domas and some texts of Potier had already been translated, the civil law in English had not yet been invented. English was the language of the common law, and some terms of the common law were used by these translators, later on to be changed, like joint and several liability that would become solidary liability. There was at the time a wish to keep the civil law tradition alive, but this did not mean that it was to be reduced to positive law. Unlike the majority of the French, with Portalis as an exception, early 19th century Louisiana jurists were not positivists. They believed in natural law, which was a source of inspiration when making sense of the newly written law. It could be traced in Blackstone's commentaries of the laws of England, as well as in the writing of civilian jurists. Back then, combining the words causa and cause and consideration was no mortal sin. Both concepts had much in common, as demonstrated by Lord Mansfield in the 18th century England, when he tried to inject moral duties into the common law. He was resisted, we know, by positivist judges. In a recent essay, thus far in French, I discussed les codes civils de Louisiane dans leur ordre naturel, looking at our codes in a natural law perspective. Natural law may have somehow vanished in Louisiana. Yiannopoulos bragged that he killed it when rewriting Civil Code Article 4, the Commons saying that natural law has no defined meaning in Louisiana jurisprudence. I'm sorry to say, and I do that with respect, it is still there and alive. Louisiana is a unique place when one rewrites the law without changing it. How often does the Law Institute Commons say, this article is new? It does not change the law, however. Vernon Palmer has eloquently described the death of a code, the birth of a digest. He is a reliable guide in navigating the swamps of the Bayou State law. Under his guidance, I am no longer lost. When translating our current civil code, contemporary translators try to identify where it comes from, as all of us come from the outside. Intimacy with the civil law tradition and with the civil law in English is not enough. Vernon's work educates us on the unique experience and history of the Louisiana civil law, and do so also from afar our companions John Cairns and Augustine Parise. We wish it a long life, and we also wish well to our dear friend Vernon. If I remain at a loss, it is of words to express my vibrant admiration and friendship. Thank you, Vernon, and thank you all for your attention.
Thank you very much, Professor Morito, for that delightful journey. And it's now my privilege to introduce Professor John Cairns, who is a professor of the civil law at the University of Edinburgh. Professor Cairns began his research focusing on a comparative study of the legal traditions of Louisiana and Quebec. He has also studied extensively the legal literature of Scotland and England in the 17th and 18th centuries, looking at the relationship between legal thought and legal education. He is His work has been extensively published throughout the globe, and we're really privileged that he is joining us tonight to speak about printing and translation. Professor Cairns, thank you.
Thank you, Dean Mayer, for these kind remarks. It is actually a considerable honor and an enormous pleasure to speak at this event, to mark not only the publication of Vernon's wonderful new book on the translators of the Code of 1808, but also to his 50 years of teaching at Tulane Law School. It's a record of, I think, brilliant achievement. For over 10 years, I have, off and on, been reflecting on the digest of 1808 as a material object, as a book rather than as a code. In these few words in Vernon's honor, I thought I might present some thoughts on this. It further seems quite appropriate, as Henry Nugent, one of the translators identified by Vernon in his discoveries, Nugent directed considerable abuse at James Bradford, the newspaper editor and printer, not only of the digest, but of the earliest bilingual volumes of the statutes of the territory of Orleans. I may add that Nugent's invective is enjoyable, if not quite equal to that of Ignatius O'Reilly, that fictional genius of the Crescent City. Legal historians of the modern period tend to take books for granted in a rather innocent way. But books are physically complicated things, and this goes far beyond questions of editions, copies, and issues. And the digest is a particularly complicated book, and this is what I want to talk about. I shall start with some basic points. On 31st March 1808, the territorial legislature gave Governor Claiborne the duty of ensuring the printing of 600 copies of the digest in both the French and English languages. The contract was to be bid for, and the lowest bidder selected. In early October 1808, Governor Claiborne organized the digest's distribution to parish judges, thereby formally promulgating it. Thus, printing the digest appears to have taken approaching 6 months. As a printed volume, the digest is a folio. That is, it was printed in twos. This means every 4 pages required a single sheet for printing. I've done the arithmetic, and this means that each copy required 130 sheets of paper. If 600 copies were in fact printed, 78,000 sheets of paper would have been required, an enormous quantity in a territory with, as yet, no paper manufacturing. But this essentially a logistical issue may well explain part of the reason why Bradford and Anderson gained the contract, supposing it was indeed put out to tender. They were already printers to the territory and had experience of printing the legislation, first of the Legislative Council and then of the territorial legislature, legislation likewise in French and English. A statute of 1806 required there to be 600 copies of the statutes, with also at the end of the second session of the first legislature of the territory, a further 400 copies printed and bound in boards. Okay. So in collaboration with a French language printer, Jean Renard, Bradford and Anderson had produced a bilingual edition of Lewis Kerr's exposition of the criminal laws of the territory of Orleans, published in early 1806. Later that year, following an 1805 act of the first session of the Legislative Council, and again in collaboration with Renard, Bradford and Anderson had printed a bilingual compilation of constitutional documents important for the territory, including the Constitution of the United States. Now, thus, this means that not only were Bradford and Anderson the printers to the territory, they had considerable experience in producing relatively long runs of bilingual legal works, collaborating with Jean Renard. And we know from a court case over the years 1809 to 1810, in which Renard sued Bradford and Anderson, that it was he who acted as compositor for the French text of the digest. Okay, so Renard set the French text of the digest. Further research is necessary, but it was certainly he who set the French text of the statutes of the territorial legislature, printed by Bradford and Anderson, until Claiborne deprived them of the office of territorial printer, I may add. And it's perhaps even Renard, perhaps even he set the French texts of the earlier territorial council statutes, but this is less certain. Okay. So what this means is that Bradford and Anderson had experience of high volume bilingual printing of legislation. They had the logistical connections for acquiring the huge volume of required paper. They had the printing capacity, and they had an established relationship with a skilled Francophone printer. Now, it is worth noting that several features of the digest are characteristic of Bradford and Anderson's editions of the statutes. Their editions of the statutes also only have an English language title page, the significance of which has been recently explored for the digest in an important article by Asia Ostru. In the statutes, the English text is also on the verse of the printed sheets and the French on the recto, as in the digest. The statutes also have a table of contents very much resembling that in the digest. And the statutes of the Legislative Council have an index of matters that again very much resembles that in the digest. So one can see that much in the digest is patterned on Bradford and Anderson's existing experience of printing the statutes. Now, Bradford and Anderson were apparently paid over $5,000 for printing the digest. I may add that Jean Renard hoped for a payment from them at the rate of $3 a page. Now, the digest is not a beautiful book. The first edition of the Code Civil des Français, for example, is very elegant, but the digest is not. This is not only because the digest is bilingual, I think, but it's also because of the kind of complex structure that was given to the titles. There are some obvious typesetting errors, which I shall not detail. If typesetting errors are regrettable in a statute, I may say they're mostly trivial. Letters dropping out of place, numbers reversed, and mistakes in pagination. These mistakes probably reflect the complexity of the printing job and also the speed of the setting and indeed the printing. Now we know that the digest was drafted mainly in French, or perhaps entirely in French. But this does not mean that the French text, as we have it, is always the most reliable. In some instances, the English text is undoubtedly superior in the sense of reflecting more accurately what was intended by the legislature. This is not a reflection on Jean Renard as a compositor. As Vernon's book reminds us, the creation of the digest was a complicated matter. Many people were involved. It was overseen by a legislative committee, and people not only translated the text produced, but they also would have made copies of it for setting. There are many ways in which errors could creep in. I shall therefore finish by looking at some problems in the French text. These are not problems of translation, since this is the text of composition, but they may be problems of copying rather than typesetting, or some may be copies of typesetting. Now, these are, I think, reasonably well-known problems. One of the most interesting is Article 21 of the introductory title. It states that in deciding according to equity, one must have recourse to natural law, of which Professor Morito has just been talking. One must have recourse to natural law and reason, or to custom, in the silence of, as it puts it, la loi primitive. La loi primitive. This provision was drawn from the 1800 projet of the French Code and should, of course, as correctly translated in the English version, read la loi positive. Either Renard or a copyist has misread la loi positive as la loi primitive, and the digest reads according to this misreading. And of course, this misreading is an easy mistake to make in the cursive script of the era. Another example. Article 54 of Title 8 of the first book concerns the inventorying of the goods of a minor child. And following the provisions of the French Code, Article 442 states in the English text or translation that this should be done in the presence of the under tutor. But the French text lacks this requirement, missing out the Code Civil, the French Code Civil's clause, et sera fait en présence du subrogé tuteur. This was either an accidental omission by Renard in setting the type, or by a copyist preparing the work for typesetting. Amiad, as in the de la Vergne manuscript, which we saw some illustrations earlier, the de la Vergne manuscript corrected this error. Finally, Article 228 of the first title of Book 3 renders what should be héritier as créancier. Now, this article of the digest is based on Article 876 of the Code Civil. The English text has the correct translation, heir, or at least has the correct translation of what was intended, heir, and this is correct, as the article concerns the liability of co-heirs. And this must be an error that appeared in copying the French text for typesetting. It's not really a typesetting error. And it's difficult to see how a skilled compositor working in his own language could have mistaken héritier for créancier. I may add that this was also corrected in manuscript in the de la Vergne volume. Now, a comparison of the two texts after setting, but before printing, would have avoided these errors. But the digest was clearly a work printed in a hurry. And these errors serve to remind us that, even if drafted in French, the French text of the digest is not always the most reliable. The translation may be better. One has always to think of the printing as well as the translation. I shall just conclude. I've always found Vernon to be a man of infinite kindness and generosity. I've known him now for many years, and he is a man of quite exceptional warmth. And I'm very much delighted to have been asked to make a contribution in his honor. And I hope he finds, and that you have found, this short contribution acceptable. Thank you for your attention.
That was lovely and well more than acceptable. Our final speaker tonight is of course our very own Professor Vernon Palmer. Professor Palmer has specialized in comparative law at Tulane for now 50 years, as we have heard, and we are so happy to commence a year of celebration of his contributions to our community and to the scholarship on comparative law and the civil law in Louisiana and elsewhere. Professor Palmer is recognized worldwide for his contributions to the field. He was knighted by then French President Jacques Chirac as a Chevalier in the French Legion of Honor, the country's highest civilian award, recognizing his work to build stronger ties between the United States and France. Professor Palmer is an elected titular member of the International Academy of Comparative Law at The Hague, and the Université of Paris Dauphine conferred on Professor Palmer the title Doctor Honoris Causa. Professor Palmer is truly revered and respected around the world, and very much none more than at home at Tulane. And Professor Palmer, congratulations on your latest achievements, and I'm delighted to turn the microphone over to you.
Thank you, Dean Meyer, for those very kind words. I'm excited, a bit overwhelmed, and truly honored by this occasion. I can't begin without expressing my deep gratitude to Tulane and this great law school, which has indulged me, tolerated me, and always supported me in every endeavor that I've engaged in over all these long years, which I hate to mention the exact number. So to you, Dean David Meyer, and to Vice Dean Sally Richardson, and to all the past deans that I've served under, now that numbers 6 deans so far, and to my dear friends who've appeared on this panel, thank you so much for those wonderful presentations. And thank everyone from the bottom of my heart. The difficulty tonight is that I probably have far too many things to talk about, so I'm going to limit myself to one question. And the question might be this: what value lies in re-examining a more than 200-year-old translation of a civil code which is no longer in force, and a translation which was carried out by two obscure figures, so obscure that they do not appear in any standard histories of Louisiana law or Louisiana history in general? Certainly Henry Paul Nugent, the Irishman, and Auguste Davisac, the islander from Saint-Domingue, are obscure men. Apart from the account in my book, there is no biographical sketch of Nugent anywhere in the world. And very little has been written about Davisac too. But these translators, unless I'm very wrong, might be called, to paraphrase Percy Bysshe Shelley, they might be called the unacknowledged legislators of Louisiana civil law. Translators of laws, whenever the translation is enacted as law, as in this case, acquire a special dignity, a special power, a special responsibility. In my view, they do not deserve to be obscure figures in our history. For one thing, the Louisiana Digest of 1808 was extremely important. It was the first European code in this hemisphere, which of course includes Latin America. It was also the first reception of French civil law anywhere in the world outside of France. And this pioneering translation of the work of Moreau, Lillet, and James Brown produced the first codification of the civil law in the English language. This is all to my knowledge. I'm waiting for someone to contradict that. So my point is that their task was totally new. Very naturally, then, I think we want to know more about these men, not only their names and national origins, but what was their prior training or their knowledge of law in general? What were their credentials? What languages were they proficient in? On what basis were they chosen by the legislature? Who were their mentors, associates, and allies? I tried to solve some of these questions in the work, which has just recently been published. But let me say there are other reasons for taking interest in this. First of all, because this story is part of a larger story about law, language, and lawyers in early Louisiana. In my view, the translation of Louisiana's first civil code was not just a convenience for English speakers. It was enacted as law. It received co-equal status with the French text. And neither text was to take precedence over the other. Discrepancies between the two were to be resolved by consulting both versions. And thus, the work of Nugent and Davisac, for better or worse, was on a par with the work of the most famous jurisconsults. Indeed, in the course of time, the English translation gained in significance, in my view, because over time, the French language, which back in 1803 at the purchase, was spoken by more than 90% of the population. But the French language was from there on destined to go into steep decline. The collapse of French in Antebellum, Louisiana, was rather astonishing in its speed, and that is well known. But this collapse made the English version of our codes increasingly important for the merchants, the lawyers, the judges, and the citizens who did not read French. Now, I would like to give credit to legal translations in general in Louisiana, not just this first one. I would like to give credit to them for the remarkable survival of civil law in Louisiana. I think it is not too much to say, some may dispute this, but I don't think it's too much to say that civil law has survived in Louisiana over the past centuries against all odds and pressures, in no small part because of English translations. I believe they were a necessity of life. Consider this. In the period 1803 to 1808, the first Louisiana bar was formed. The majority of these lawyers, and there's a study recently that has been made of the composition of the bar, the majority of these lawyers were American lawyers who poured in from the United States. Usually, they did not read French, had not been to university, had never studied civil law, and were therefore unfamiliar with codes, although this is the dawn of the age of codification. The translation by Nugent and Davisac, I believe, was their guide, if not their Bible. By the time we reach early modern times, which is to say the late Middle Ages of my life when I studied law at Tulane, no judge on the Louisiana Supreme Court at that time could read French or could access French doctrine. And this had been the case for some time. So as a means of breathing new life into the fortunes of the civil law, we, the Louisiana Law Institute, translated a good number of French legal classics like Planier et Ripert, Aubry O. We have had to live the civil law experience sometimes indirectly through translation. Our translators have been going back to Shelley, the unacknowledged midwives of the rebirth of civil law in Louisiana. Coming back to my lost translators of 1808, there's another aspect to the importance of this work. Not my work, I mean the work of the translators. The work of Nugent and Davisac, in my view, set in motion the search for and the discovery of a new language that might be called civil law English, or perhaps juridical English. This search for civil law English continues to this day, for example, through the superb efforts of my colleague Olivier Morito and Alain Levasseur at LSU. Now, we all know English, but do we know civil law English? It is, of course, a language within a language, a second kind of English. Like Monsieur Jourdan in Molière's Bourgeois Gentilhomme, when he discovered to his surprise that he was speaking prose when he asked his wife to bring his slippers. Our lawyers have been speaking this second language without knowing they were doing so. As mentioned earlier, the civil law of Europe, of France and Spain, which was implanted here or codified here in 1808, had never before been legislated in the English language. At that time, English to the Creoles was a foreign language. It was the natural language, or better, the native language of the demonized common law. So Nugent and Davisac had the delicate task of transferring the continental wine into new bottles. Accordingly, they told us that an obligation solidaire in French was joint and several liability, the expression of the common law. They told us that créancier et débiteur in French should be called obligé and obligor, the expressions used in the English common law of bonds. They told us that bonne foi and mauvaise foi in French should be translated in various ways, some of which were very strange. But my point is that whether right or wrong in their decisions, and I think they were frequently wrong, they were doing important work whose impact was second only to the impact of the jurisconsults. And I would like to make one final comment before I close. The translation of 1808 not only helped to create a new civil law English language, as I said a moment ago, but in the process, it inevitably produced a kind of conceptual reception, a tacit and unavowed reception of some common law ideas. To my knowledge, this tacit reception has never been sufficiently noticed or appreciated by Louisiana lawyers and scholars. For in transposing common law terms, which they deemed were roughly equivalent in meaning, they started the Louisiana civilian down the road to unconscious hybridity. Like Monsieur Jourdain, the bourgeois gentilhomme, we began speaking a certain amount of common law prose for the past 200 years without even knowing it. Thank you, ladies and gentlemen, for the honor of speaking to you about my lost translators. It has been an enormous pleasure. Thank you.
Thank you so much, Professor Palmer, and to all of our panelists tonight. This is such an important project. While Moreau, Lillet, and Brown get so much credit for writing our civil code, certainly our translators deserve great credit too. Identifying Nugent and Davizak is important. Understanding their background, their history, all helps to explain, as Professor Parise said, the tool that was used as the translation, and also explains much of the pattern of errors, or perhaps, as Professor Cairns mentioned, improvements in some of the translations that occurred. Listening to Professor Morito's explanation of the change, the example from ownership and possession, almost makes the translations sound like a playground game of telephone, extending from example to example with slight deviations each time. And so as we start the Q&A portion of our evening, please feel free to put questions in the chat box that we can send to our panelists. And if all the panelists might want to comment, though, on the first question that we have, and that is looking forward, what will the role of translations be in the future? Professor Palmer noted that translations in the early 1800s were a, quote, necessity of life. They led to the survival of the Louisiana civil law. And so where today we also know there are many translations occurring, where will these translations take us in the future? How will they impact law globally 50, 100, 200 years from now? Will others be gathering like this to talk about the backgrounds of our modern translators looking forward? And I invite any of our panelists to jump in and join and make their comments on where they believe the role of translators will go in the future. Professor Morito?
If I may, I will start with a dystopia. Imagine a world where everyone and all over the place, English becomes the common language. Probably groups, national groups, minorities, and so forth will think we need to have what is said accessible in our native language, and that would trigger an enormous amount of translation. So whatever happens, whether we promote language diversity or move to a common language, we will live in a world of translation.
Professor Parise?
Yes, thank you, Sally. I take the opportunity to thank you, Sally, also for the invitation. I wanted to pick up on your point, Sally, about the future, what could happen. And I would like to return to my presentation where I refer to bridge building activity. I think Louisiana, but all the other civil law jurisdictions, or at least let's say all the jurisdictions should engage in dialogue. Why? Because I think that if we engage in dialogue, if we look at others, if we share our experiences, if we learn from the experiences of others, and translations could help in that sense, we could continue developing, if we look at the civil law, for example, we could keep developing civil law terminology, civil law ideas, because we have to be reluctant to believe, we should not believe that the civil law will be something static, that will always be looking back, all the way back to Rome. No, of course, we're going to go look back to Rome, but we should also look ahead, like you just pointed, Sally. And when we look ahead, if we're open, if we engage, if we build bridges through translations, we could make the civil law something alive, something that grows, something that develops, and above all, something that reflects society. And that brings us back to social sciences and the place of law as a social science. Thank you, Sally.
Professor Cairns or Professor Palmer, what do you think is the future?
Well, I would say looking forward, we have to realize we are now here in Louisiana, we are now in one language. We no longer have much of a French text to compare to our English language code. And Louisiana is now committed, I would say, to having not a bilingual code and not a code that can be corrected by an underlying French text. Although historians may still do that, I don't think the actors in the legal system are going to be doing that. But I agree with Augustin that we need to reach out and show the Louisiana experience to others. We have a pretty remarkable civil code now. I once wrote that there was a death of a code, but that was a long time ago. We have made tremendous strides since I dared to say that. And we need to be able to communicate in other languages about our Louisiana experience, even if we ourselves are totally in English.
In looking back, we also had a question raised. Was there a conscientious effort to try and keep the identities of the translators of the 1808 Digest anonymous?
May I try answering that?
Please, the stage is yours.
Well, I can only think that it would be a conscious effort on the part of the translators themselves. They knew they had performed the translation. Why didn't they come forward to brag about it at some point or tell someone else? I think a lot of people knew, in fact, who the translators were. There was, as John Cairns mentioned, a legislative oversight committee. There were those who appointed in the legislature who voted for the appointment of translators. So it wasn't a secret. It just is, but I think it was a secret that might have been created by the fact that as soon as the translation was published, the governor criticized it terribly. He wrote to the Secretary of State, James Madison, that it is an extremely incorrect translation. I don't think that the governor himself could have been in a position to make that judgment, since he didn't speak French, nor did he know the civil law. I think he was probably reflecting some advisors or other members of the bar who told him that. But I think that might have been the first reaction, and it might have silenced the translators from coming forward, or from, there's another possibility in my mind, that being a translator was not necessarily, you were not a professional translator at that time. Everyone in Louisiana who was anybody seemed to be a translator. Morito was a translator. Livingston was prepared to translate the entire Justinian's Digest. James Workman was prepared to put ads in the newspaper to translate all of Spanish law, the partidas and everything. There were quite a few translators, but they were not professionals. They rose to the occasion out of a kind of feeling of necessity that they may have been aiding the legal profession if they did these things. So I don't think that there was perhaps the feeling that they needed to brag about their accomplishments.
Professor Cairns?
Sorry. Yeah, it's an interesting point. I mean, as Vernon has pointed out, there are lists of people who are paid in statutes setting out lists of people who are paid for the work on the digest. And there are people other than the two translators who are getting sums of money for this and this for I think Augustine mentioned sundry tasks and things like this. And so, and there must have been, if you think of the volume of work that is involved, it's very difficult for us now to think of this when you live in a world of photocopiers and computers and endless reproduction of documents. But we were talking about manuscript culture, where there must have been lots of clerks copying out articles, titles, things like this, and so there must have been a lot of people involved as well. And as Vern just said, there was an oversight committee of literature. It must have been known at the time who they were. And it was just never something anyone particularly thought clearly was important. It may be, as Vernon has hinted at, it may be because of the extraordinarily strong criticism given by the governor of the translator. But Claiborne was kind of paranoiac in so many ways, who was always felt under attack. And he was using attack of others as a means of defending himself in saying these kind of things. So, but it must have been pretty well known. Who did it, at least Morito, Vernon mentioned Morito, Morito translated the legislation of the Legislative Council, and at the end of the printed statutes, it says he is authorized, he certifies it as being correct. It's like Morito, translator, things like this. So which interestingly suggests that those were drafted in English and translated into French, but it must be known, but just nobody for some reason thought it worth discussing extensively. And but New Orleans at that time is a small society. I've often regretted that nobody's done a proper prosopographical study of all the people who come in as lawyers, because if you look at who appears in courts, it's the same people again and again and again, and they're interconnected. They're related to one another. I'm pretty confident that James Bradford became printer to the territory through James Brown, who goes on to be one of the redactors of 1808, because Bradford's seeking patronage from James Brown's brother and things like this. So they're all pretty interconnected. Everybody must be widely known who translated it. Sorry, I'm rambling a bit. I'll stop.
No, well, Professor Cairns, we have time for one more question, and let us start with you in answering the question and combining a few questions that have come in. Might it be that the identity of the translators was sought to be concealed as to preserve the idea that this was the word of the legislators, and to perhaps take away the taint of any bias or political motivations that the individual translators may have?
Yeah, it's possible, but I find that implausible.
Professor Parise, Professor Morito, Professor Palmer?
If I may, on this, just an anecdote showing that the person of the translator must stay below the stage. When I presented my French translation project in Acadiana, in Lafayette, or when I meet lawyers in a restaurant in Lafayette, they say, "Oh, your work is wonderful. We have to bring it to the legislature and pass it into law. After all, the present constitution acknowledges our linguistic and multicultural origins." And I'm telling them, well, friends, You do the politics, I do the translation. I think the work of the translator should be behind the stage and shouldn't be too visible when we translate the law. I'd agree with the comment by Mariano Viteta. Thank you.
Professor Parise?
Yes, thank you. Just a short follow-up. When I was going through Vernon's book, Vernon's always trying to make sure that he covers all the possible alternatives of why things went one way or the other, sometimes in the body of the text, sometimes in the footnotes. And there we have I think we have to try to place, like Vernon does many times in the book, tries to place these two translators within the who is who that Vernon refers to, and the way that this who is who would also collaborate to the extent of perhaps lending books from the library, pointing to a specific author. For example, the reference to Doma and the English text that is taken from Doma, it would sound strange that Morito plays the hiding the ball. He wouldn't hide the ball. He most probably would tell them, look at Doma. So these are things that, of course, we are not able to find yet, but maybe in archival work, we can start to find some of these connections between the who is who and the role of books, of networks, of what Louis de Laverne many times spoke about these actors in the foundational period. And like John Kearns just said, if we could try to he didn't say this, but I visualized what he said as a trying to map individuals in a network analysis, for example, something very trendy now. We could do network analysis of all these actors. We could try to see how ideas and models went from one place to the other, in our specific case today, through translations.
Well, Professor Palmer, it seems only appropriate for you to have the last word.
Well, just a short follow-up to that point. Yes, it's very important, I think, to know who is who. Just to know, for example, one of the translators is the brother-in-law of Edward Livingston. His sister married Edward Livingston, Louise, and he articled or apprenticed in Edward Livingston's law firm. He dropped everything. He was a trained doctor. He dropped everything to become a lawyer as soon as he got to New Orleans. So it's very important to know their connections, I think. That may be the avenue by which he was secured as the translator because of Livingston's influence and his eminence. But going back to the earlier point, I don't think it is plausible to say the relative anonymity of the translators is due to the fact that the legislature would not want to place them in a high position. After all, Morito and James Brown were put in a very high position, and they were their status was declared, and they were called jurisconsults by the legislature in the statutes that described their activities and their appointments. So the legislature, in my judgment, was not afraid of losing prestige in any way. If I go back to the instance of Morito and James Brown.
Thank you all so much for participating in this virtual conversation tonight. To our panelists, to our esteemed colleague, Professor Palmer, to Dean Meyer, and to all of our attendees tonight at this virtual conversation. It has been an enlightening, an engaging, and intellectual dialogue, and one that Tulane Law School looks forward to continuing for the next year as we celebrate Professor Palmer's contributions, not only to Tulane Law School, but also to all of Louisiana law and comparative law more broadly across the globe. Our congratulations to Professor Palmer for the publication of his book, The Lost Translators of 1808 and the Birth of Civil Law in Louisiana. We give you a virtual applause and look forward to applauding you in person. And thank you all for staying with us this evening. We have appreciated your attendance here.